atushike, atulete mahakamani, atustaki, atupeleke exile, atulize.
Si ati napita. Mimi sisimami hapa. Acha nipite.
So, Mr. Juru, you can... Okay. Or you can take your time.
Jayne Kihara has just come. He's appearing confused. I'm not ready for being in a public gathering, uttered words to wit, open court. I want to talk about Naivasha because I know those goons were transported in NYS bus in a place called Karangita. They were dropped there. In town, they were brought in trucks in Maimayu. So all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were destructed, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven. And what you are doing now is digging deep so that they go under. It will not happen. In Naivasha, they killed 1, 3 are in critical condition. And as my colleagues have said, police are doing anything they didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. We could see in the place goons working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot, we as Kenyans are prepared to prepare our country so that you cannot be drowned by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and current MP, Member of Parliament representing Naivasha constituency. The suspect was represented by a battery of counsel. They were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kiragu, Mr. Ndego Njiru, Mr. Wairegi, Mr. Malemba, Mr. Nyambu, Mr. Wambugu Wanjohi, Mr. Mageto, et al. They are quite a number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witi JV, Ms. Sonia, and Mr. Momanyi. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vivaciously opposed the suspect from taking plea. So that is the kernel and quiescence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct, contra section 94, subsection 1 of the Penal Code. Senior Counsel adjured that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particulars does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby imploring selective and or discriminative prosecution. Senior Counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backcloth of the misdemeanor charges that now the accused has been arraigned. And therefore he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara beseeched that the particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of her constituents and which she exercised by dint of Article 33 of the Constitution. Mr. Ndego Njiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of stare decisis. He entreated that pursuant to Section 8.1 of the Magistrates Court Act, this court is closed with the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of or threat to a right or fundamental freedom in the Bill of Rights. He thus urged the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njiru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principle of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the contextual milieu of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94.1 of the Penal Code. He buttressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic and civilized society. Council basically urging that the three ingredients to the offence has not been disclosed sufficiently, concomitantly offending Article 52B of the Constitution. The Learned Counsel not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct. Conversely, on behalf of the state, Mr. Whitty vehemently opposed and balked the application. He, citing the old aphorism that a court of law down its tools in respect to or matter before it, he reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, Learned Counsel argued that under Section 828 subsection 2 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to Article 2, Sub-Article 2 of the Constitution, this court has no powers to legislate. Learned Counsel further, Mr. Whitty, submitted that the relevant law governing the framing of charge sheets are found under Section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of the offence and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredients, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan, Masharia versus KCB and others, 2012 EKLR, which the court held, and I quote, by the Constitution or other written law, it cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law, through judicial craft or innovation, end of quote. I'll also cite the famous case of owners of motor vessel, 1989, EKLR, where I'm sure all of us are familiar with this authority. So I'll note, stated by both parties, the jurisdiction of the Magistrate Court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. The parameters, despite being pellucid, stated under Section 8, subsection 2 of the Act, has also found fortification in the Supreme Court a decision of Hussein Khalid, which I've quoted before, herein above, where the Apex Court, whose decision is binding before this court, enunciated thus, and I quote, Parliament has granted to the Magistrate Courts powers to consider applications on alleged violation of the Bill of Rights, but has limited the power to only two rights under Article 25A and B. And that, according to the Apex Court, is that one is for the freedom from torture and cruel, inhuman or degrading treatment or punishment, and also the freedom from slavery or servitude. I proceed to quote the Apex Court. This limitation is constitutional, as Parliament does not bar a person from bringing a case alleging violation of his right, but only limits the forum where that cause can be done. They have cited this was captured by the High Court of Australia. I'm not going to those. You can have it once you have this ruling. So I'll share with you so you'll have a look at it. So flowing from the foregoing, it is crystal clear and need not be belabored further that this court can only enforce rights that fall within Article 25A and subsection B, paragraph B, sorry, of the Constitution. Therefore, on the elemental question of jurisdiction, I will down my tool. So I go to the second question for determination, and that is on the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and in the exercise of his powers or functions shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, Sub-Article 11 requires that the holder of such office to have regard to public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are plethora of authorities on question of the competence of framing of charge sheet. So I'll not go into that. I'll go into Section 134 of the Criminal Procedure Code that states, and I quote, "Every charge or information shall contain and shall be sufficient if it contains a statement of the specific offence or offences with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offence charged." End of quote. I'm not going to this, Section 176. I've elaborated the provision of that Section 137. So, in the often cited case, in the realm of framing of charges, the case of Sigilani versus Republic, 2004, 2 KLR 480, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test for whether a charge sheet is fatally defective or incompetent. I'll not cite it. So indubitably, therefore, a charge must therefore be clear and easy to understand. In as far as possible, the use of technical language in a charge sheet ought to be avoided. An accused person must be accorded an opportunity to understand what he or she is facing before court. I've cited the authority of Benson Hatwenge Wafula versus DPP, that is petition number E045. So I'll go to the finality of the finding of the court. So in Adjournment, I find that the requirements of a properly drafted charge sheet has been surmounted by the state. I find also on the face of the charge sheet, I'm of the conscientious view that the suspect will be able to fathom and adequately discern and be able to prepare for her defense. So the finding of this court is that I'll direct the suspect to take plea in respect to the charge sheet that has been presented before court. Yes.
The defense would like to make an application to confirm the taking of the plea today. Get the views of the constitutional court, still holding her guard, because he's entitled under the Bill of Rights not to say anything to the charges, to confirm whether she had the statements or not, to make a reference so that the constitutional court is in a position to define the parameters of the constitutional privilege and the license of a member of parliament. When you are addressing addressing your constituents' grave issues as a breakdown of law and order. The property destroyed. Lives have been lost. And I think a number of issues are very clear, even from the ruling, that she's a member of parliament, that is not in contention, that she takes a much wider license in terms of her freedom of expression, and that we, as read together with the parliamentary statutes and the separation of power doctrine. I'll have my colleagues here assist further, but the only thing I may mention, so that we ask you a short time limit. We propose 14 days to be able to go to move the constitutional court. You have to appreciate that we are also going on vacation, so we may not be sure whether we will get a date as fast as possible. Your Honor, the only thing I may mention is that we need to see this license in terms of even a judicial officer. Tomorrow could be arraigned on the basis of a judicial decision or a statement made in court. I do think that you think it's far-fetched, but we are living in very uncertain times. And I think it's good to mention that, so that we appreciate the doctrine of separation of powers and the license that goes with that office of a member of parliament in regards to her constituents' issues involving security.
On section 33, in as much as I would be really wanting or urging to make such determination, but my hands are tied.
Yes,
Yes.
yes, you actually want to address why your hands are not tied, and
therefore to require a constitutional interpretation on what constitutes to a crime by a citizen of this republic, and also what constitutes a crime by an elected member of parliament. An elected member represent people in various legislative bodies. This is informed by the fact that the role of an elected member is, number one, representation. Number two is legislation. And number three, Your Honor, is oversight. And therefore, when a member of parliament makes a statement on the state of affairs in his constituency, and then that statement is criminalized, Your Honor, I would say without any hesitation that if that's the case, we no longer have a country. And therefore, that's why I urge you kindly to allow us to have that interpretation in the Constitutional Court, and we defer the taking of the plea of the accused. Thank you, Your Honor.
But you give us a state of jail ruling for 14 days, and you all at the same time state taking a plea, so that a very important constitutional matter can be explored, probably in a manner it has never been explored before. The other reason is that this sort of charges have become very many recently, and the courts needs to state its position squarely, which has not been done before. Otherwise, these courts are going to be flooded with similar cases, overload the court system unnecessarily, and even spend the public money wrongly on the part of prosecution and on the part of judiciary, pursuing cases which will end up in a divorce. And that's why we are pleading with you that you stay your ruling and you also suspend the charges so that we may squarely now go to the courts fully entitled to interpret those sections and your Honor Justice is because of the country.
And give you the justification why you ought to grant us an order of stay. This order of stay we are seeking, Your Honor, is akin to the orders granted by the Court of Appeal, the famous Rule 5.2b. And therefore, Your Honor, what we need to satisfy you with is whether or not there is a justification for that stay. It has been urged before Your Honor that the chargeship borders between violation of fundamental rights. Therefore, the question to answer is whether or not, if that charge is read and plea taken by the suspect, whether it will amount at the fullness of time to a violation. Whilst answering that test, Your Honor, we shall be answering the question of rendering the intended constitutional petition nugatory. If she takes plea and then we move tomorrow to the High Court or today to the High Court, will it be an academic exercise? Will it amount to an academic exercise? That is a test that will the court ought to apply. Number two, Your Honor, is a test that granted the magnitude of the petition that we intend to file and the consequences that will befall the accused person if she were to be found to be guilty would eventually culminate to a fine of 5,000 or 6 months imprisonment. That is to say, therefore, the violation may be much more surmounting than the consequences that will befall her. The other test is whether there shall be any person who shall suffer prejudice. And the state being the complainant, and in the absence of a private citizen who would fall in the category of a victim, the balance tilts in our favor. That there is no complete natural complainant, natural person, saying that Honorable Jayne Kihara has wronged me in this way, and therefore the delay will occasion injustice to that particular person. Because this is an alleged offense against public order. The other justification, Your Honor, is that we need the High Court to expound on Section 8. And this is a justification, Your Honor, that Section 8 cannot limit you to the only rights under Article 25, A and B. Because A and B speaks about torture and being subjected to slavery and servitude. Yet today, or even when we appear before you, you exercised a right under Article 49. Article 49 is not what is encompassed under Section 8. Therefore, to say that Section 8 is constitutional would therefore mean that you today you not even have the ability of exercising the rights under Article 49. Because Article 49 is not covered under Section 8. It therefore means that all these courts have been acting unconstitutionally. Number two, Your Honor, while Article 25 speaks about the non-derogable rights, among them Article 50, the fair hearing is not encompassed, is not protected under Section 8. Does it therefore mean that this court will not, or any other magistrate court, cannot exercise that right under Article 50? Because Section 8 limits The other justification, Your Honor, is that this court is enjoined by Article 10 to enforce the Bill of Rights. Article 10, which binds all state organs, state actors, state, whenever any of them is interpreting the law or applying the law, is not covered under Section 8. So the question that will be put into the High Court is, can Article 10 give and Section 8 take away? So those are very fundamental issues that will settle the law on the ability of the Magistrates Court to enforce the Bill of Rights. Because Article 10, Your Honor, provides in a blanket way that you must enforce a Bill of Rights. It is protecting them from denial, from infringement, from violation, or even from a threat. And therefore, to protect that foreseeable threat, the application for stay is justifiable. And it's not just justifiable, it's justitious.
Whether the charge sheet that we presented before you was proper under Section 134 of the CPC, the suspect hearing will be able to defend herself or rather understand the charge well enough to put in a defense. And those questions have been answered in the affirmative by your ruling. Yona has also distinguished what pertains to freedom of expression under Article 33 and whether this court can deal with issues pertaining to limitation of some rights under the Bill of Rights, and as rightly stated by the court and the authority that the court alluded to, the only violations that this court can entertain in line with Section 8 of the Magistrates Court Act are the ones under Article 25A and B. Yona, at this point in time, plea taking may not bar the defense from moving to the High Court for a constitutional interpretation. Decisions of any court higher than this one are binding on this court. I have not heard them indicating to us the prejudice that the suspect will suffer once she takes plea. The office of the DPP will also be bound, is also an office that is bound by decisions of the higher courts. When we were here last before you, the argument by the defense was that the charge sheet presented offended sections of the law that the court has dealt with. So, it is our submission that nothing bars the suspect from taking plea at this point. They can move to the High Court for interpretation of the section of the articles that they indicate. Once the High Court pronounces itself, then this court will comply with those orders. So at this point in time, the suspect is before court. The court has indicated that the charge sheet is proper. So we oppose the application for deferment of plea.
You say this, if I allow this, it will be a threat to MPs. Submissions. So first of all, I'll share with you the ruling on the question of the charge sheet and the other issues that were shared. and then I'll request you to come on Tuesday next week,
You're most
5th.
obliged.
So in the meantime, I'll extend the bond terms
You're most obliged.
because I granted a personal bond term.
You're most obliged.
But one thing I'll want to request, as a court is a hallowed temple of justice.
Yes,
yeah?
Your Honor. That's fine.
And we won't want to be, we are political
Yes.
as a court. Yeah?
That's correct, Your Honor.
So,
That's why I never said one time.
yeah, so some statements. Yeah? But you just said, eh? So some statements, and I was told, and I take judicial notice, I was told that there were chance of that, what you just said. Yeah? So I'll just respectfully,
You're most obliged.
with all humility, I think, so that we can maintain the dignity
That's correct, Your Honor.
of this hallowed temple of justice.
That's
Let's not utter such words.
We'll advise my
Once you're
colleagues.
out there at the gate, you can shout on top of your voice, yeah? But once we're within here, let's just, you can sing the national anthem,
We agree
because I'm
on
told
this.
last time you guys, which is quite patriotic,
We agree on
but some of those utterances or chants, let's just keep it off.
We agree upon and apologies.
Yeah, because we want to maintain the dignity of the court.
We are most obliged.
Because we are purely apolitical, yeah?
We are most obliged.
Yeah. Because we have to speak for each and everyone.
Absolutely.
Whether you're a member of parliament, whether you're a normal citizen, yeah, we're all equal before the law. So let's just respect that. Let's not, once I leave, I am told that, like last time. So
No, you know,
respectfully, so I've extended her bond terms to Tuesday, the 5th of August.
We are most obliged.
Okay.
You know, kindly allow us to convey our apology that will not happen again.
Okay, thank you.
And we shall allow them to sing the national anthem, but that will not happen again. Your Honor.
Okay.
Related cases.
Okay.
We are most obliged.
So can we agree also on the time?
Everything will be okay.
Because that one will be a brief ruling.
Sorry, I'm corrected by Madam Fred, who happens also to be a member of parliament. That it's 7. Yeah.
7th is okay.
Yes, we are requesting for 7.
At 11, Your Honor.
So 7 at 11. So it will be exact at 11.
We are most obliged.
Okay, so I thank you, and also for you understanding it. I was a bit late. My sincere apologies.
It's okay, understand.
But in the evening, you'll get the ruling, and maybe you interrogate it further. Yeah. All right, thank you.
You are being courteous.
Yeah.
Another court will say, I want to excuse the politicians.